Greetings, comparative environmental law, natural resources students. And when I say students, of course, it is all of us, because students are those who want to learn, including about environmental law, including activists, environmental activists, and concerned citizens for that matter. Last week, I outlined toxic waste disposal, the law governing toxic waste disposal, and this lecture too relates to water pollution and water protection law in the United States. Then I will give a few definitions. In this lecture, I'll give a few definitions, as well as issues of jurisdiction. Then I will also talk briefly, outline the challenges that a few African countries face in terms of water pollution caused by the mining industry. And then a few definitions of how to detect, how the US law detects sources of water pollution. The main law governing water pollution in the United States is called the Clean Water Act, 1971. And the purpose of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. That is according to Section 1251A of the Act. To restore, of course, is to bring back the quality of water in case any pollution happens. Maintain, we're talking about preservation. How do you preserve water quality? You, of course, you use the law and regulations to preserve it. When we talk about chemical, physical, and biological integrity, we are talking about the organic nature of the water itself. Integrity, of course, dependability of this water resource, of consistency and reliability of this water resource. Of course, when we talk about water resources, we're talking about lakes, we're talking about rivers, we're talking about wetlands, and these are surface waters. There are prohibitions in the Act. The Act prohibits the discharge of any pollutant by any person. And in terms of definitions, Section 1361 or 62A broadly defines the discharge of any pollutant to mean any addition of any pollutant to navigable waters from any point source. A point source can be a pipe or a drainage. These are called point sources because they point to the company that is discharging pollutants to a nearby water source, a nearby lake, a nearby river, a nearby wetland. So these are called point sources. They point to the source. That is why they are called point sources. These are normally pipes or drains. Pollutant is defined to include not only traditional contaminants that are known in the industrial process, but also solids such as dredged soil, rock, sand, the cellar, that is lower ground dirt. These are all defined as all of these fall within the definition of pollutants when it comes to water quality. The Act defines navigable waters. The Act talks about navigable waters of the United States, but navigable waters mean all waters of the United States, including some waters not navigable in the traditional sense. That is according to the Act, including wetlands. Wetlands are not navigable, but they are still considered waters of the United States, and especially wetlands that possess a significant nexus to waters of the United States. Wetlands that are connected or close to a river, or close to a lake, or close to a lagoon. All these are considered waters of the United States. The Act, the Clean Water Act, does not cover groundwater, because there are other acts that cover clean groundwater, such as the Safe Drinking Water Act also covers groundwater. Resource Conservation and Recovery Act also covers groundwater. Now let's go to the issue of jurisdiction in the United States. The case of Marks v. United States, 1977, that was under the US Supreme Court. Of course, when the US is a common law jurisdiction, and many African countries are common law jurisdictions. I think South Sudan is a civil law jurisdiction, because it was part of Sudan, and the Arab world, France, and other parts of civil law jurisdictions. So it's better now to move as an independent state. We need to become we need to get into the common law tradition of the UK. That is the foundation of the law. It's more effective. It's more effective. It builds more lawyers and more engaged and knowledgeable lawyers. People like Nelson Mandela. You have Barack Obama. You have Gandhi. You have PLO Lumumba. You have so many, Mahatma Gandhi. All these are products of common law jurisdiction. A common law jurisdiction creates more informed and more knowledgeable lawyers. So we need to move from the civil law jurisdiction to the common law jurisdiction, where a case law combines with statutory law, and case law provides precedents. But this is not the main topic. It's just because this Marks versus United States case talks about the federal jurisdiction. It established a plurality test. That's a directive from the U.S. Supreme Court to environmental protection agents to apply this plurality test in order to determine whether a water source is a water of the United States, and therefore comes under the jurisdiction of the federal government. The plurality test looks at the adjacent channel containing whether the adjacent channel contains the water of the United States, whether the adjacent channel to the source of pollution, the adjacent channel is a lake or a river or a permanent body of water that is part of the waters of the United States. If yes, then that is waters of the United States. The second test is the wetlands itself, because this case deals with the pollution of a wetland. The wetland has a continuous surface connection with that water, with that lake or that lagoon or that river, making it difficult to determine where the waters end and the wetlands begins. These plurality tests are directives from the Supreme Court to environmental lawyers, to environmental protection agents to use to establish jurisdictions. Water resources are so important that in the United States, they come under federal jurisdiction. not local government. Of course, county governments and state governments have also water protection laws, but they all come under the Clean Water Act. That is the jurisdiction of the federal government. Therefore, if looking at Africa, for example, the manufacturing and mining contracts that involve local governments, if we are talking about a federal system or a local government system in Africa, when you have, if these local governments are constitutionally entitled to enter into contracts with for mining, for example, or manufacturing, then they all come under the jurisdiction of the central government as well. So environmental protection cannot be delegated. This is the lesson, and especially water protection cannot be delegated to state governments. Now we talk about dredge materials, because we said that groundwater, we said that water pollution or pollution itself is not about traditional pollutants, but also dredge materials. Dredge materials, because these dredge materials could be mixed with industrial toxic sludge or mud, because industrial toxic sludge may contain lead or arsenic or mercury or cyanide. All these are used especially in the mining industry. For example, cyanide leaching. When you have gold minings, these gold mines use cyanide to leach or to dissolve gold from ore. They also used liquid mercury to dissolve gold. So the mining industry used harmful chemicals that find themselves into water sources. An example in Africa is the Galamsey phenomena in southern Ghana, where you have artisanal miners polluting water sources. In terms of, these are millions, 2 to 3 million inhabitants of southern Ghana depend on artisanal mining and are now engaged with Chinese companies. We thought that China would be a better partner to Africa, but unfortunately, the Chinese companies, the Chinese equipment that are brought to places like southern Ghana, for example, and other parts of Africa, including DRC. DRC has been going through this problem for so many decades. But the Galamsey phenomenon has really led to a lot of erosion of rivers in southern Ghana, and because artisanal mines are not regulated, then you will not be able to control them. You will not be able to stop them from polluting these rivers, apart from completely banning them or giving concessions to big mining companies, like in the case of South Africa, for example, because you can regulate big mining companies, and you can include in mining contracts certain clauses, such as that gold extraction should be done through cyanide-free technology. Cyanide or liquid mercury are used in the gold extraction, but sometimes you can ask, if you enter into a contract with a company, you ask or demand that when you are negotiating, that they use cyanide-free technology. Of course, cyanide-free technology is more expensive, and these companies want to get more profit. That is why they use cyanide as a means of dissolving or leaching gold, separating gold from ore. And this takes us to the concept of resource curse in Africa, where Unlucky populations are the populations that live on land where mineral deposits are found. The irony is that when when mineral deposits are found in a village, for example, that should be a blessing, right? No, in Africa, that has become a curse. Once gold is discovered in your region, in your county, in your village, then that is the end of your way of life, because your rivers will be polluted by cyanide. Your soil will be, the forest cover will be completely decimated. There will be no forest cover, and you will not be able to fish. And all these things are creating a resource curse in Africa, because we allow so much artisanal mining, not regulated mining. Of course, the oil industry is a major polluter, but of course, oil pollution, because of the scale of oil pollution, it's always covered under a whole different law that focuses on oil pollution. The definition of discharge of dredge material is any addition of dredge materials into the waters of the United States. That is according to National Association of Home Builders v. US Army Corps of Engineers. That's DC Circuit 2007. The US Army Corps of Engineers is the only body that will give you a license to discharge anything into the waters of the United States, in the sense that this is a centralized issue in the United States. It's not given to states. The case of California Wildlife Federation v. Toulouse, that's 1996, talks about a de minimis exception of incidental soil movement. Sometimes when you're doing dredging, you take sludge or from one source to another, and so that sometimes there are incidental soil movement that will get into waters of the United States. But for example, in Africa, when you have these pits, mining pits, or even surface mining, that the companies use, especially artisanal, in terms of artisanal mining, they bring this equipment. They use suction dredging. That is a lot of water, is water intensive. You push a lot of water and you suck that water from the mines. And of course, when you have cyanide, when you have these chemicals, then these chemicals will get back to the water source and pollute these rivers. Southern Ghana is devastated. Many parts of eastern DRC are devastated. Of course, when we look at the Great Lakes region in Africa, I don't think it is only comparable to the Amazon rainforest in terms of the number of lakes in the Great Lakes region. Tanganyika, Nyanza, you have Tana in Ethiopia, you have Victoria in Uganda, and now oil has been discovered on the shores of Lake Albert. On the DRC side, there's a huge deposit. On the Ugandan side, there is also a huge deposit, and a concession has been given to Total to extract that oil. Let us hope that there will be strict regulations to protect these, Lake Albert from pollution. Dredge materials is defined as any addition of dredge materials into the waters of the United States, including redeposit of dredge materials. A redeposit, that's what I just mentioned about especially in terms of Africa. That's the suction dredging, pulling water from pits, from mining pits. Pollution from a non-point source. This is pollution from a point source. You can directly point to the company that is, you are polluting this source, this river, this lake, and this wetland, and you must account for any cleanup of your pollution as a company. In terms of non-point source, a non-point source is pollution from a source that is not a pipe nor a drainage, for example. But then the question of a non-point source was looked at in the case of County of Maui v. Hawaii Wildlife Fund by the US Supreme Court in 2010 as a precedent. The question before the court was whether a permit is required from, of course, US Corps of Engineers when a pollutant that has originated from a non-point source can be traced through groundwater up to navigable waters. This is a question of pollution that goes to groundwater. Of course, not all aquifers are connected to rivers, but there are certain aquifers, that is groundwater, that is connected to the river, to a river, a nearby river. So if this non-point source can be traced through groundwater up to a navigable water, then does it require a permit? Of course, permits are not always given. In fact, it's rare that a permit is given for any discharge of a pollutant into waters of the United States. The court held that yes, a permit is required when such non-point discharges are the functional equivalent of a direct discharge. A functional equivalent of a direct discharge is that there is no difference between a point source, pollution from a pipe or from a drainage, and pollution from a non-point source. A non-point source could also be agricultural runoff, for example, when there is rain and you have an agricultural scheme around. Of course, you have you use chemicals in your agricultural schemes, and when there is a runoff, then that chemical will be washed into waters of the United States. The second case that confirms the first case, or it was actually before the first case, was Rapunzel in 2006 v. United States. Here it also says that yes, permits would be required even for non-point source pollutants. For pollutants that do not emit directly into covered waters but pass through conveyances in between. These conveyances could be also ground water. Groundwater is a conveyance too. When can we trace? What do they mean by fairly traceable or not? Fairly traceable is that is not disputable to the original point source. It's not disputable that that company is responsible for pollution, for this pollutant, because we know that it is only that company in that region, in that county, that uses mercury, that uses cyanide, that uses these chemicals in its industrial process. There are 5 facts that should be considered in terms of traceability. Whether a non-point source discharge was a functional equivalent. We talked about a functional equivalent, that is, there is no difference between groundwater and a pipe or a drainage. The distance that the pollutant must travel from the point of discharge to the federal waters. The distance also matters, because you cannot assign a pollutant to a company that is 500 miles from a water source, 500 miles from a lake or a river or a wetland. The distance also matters before assigning blame. Time also matters also in that. The conduit or the material that was used to convey this pollutant from this source to the water also matters. Later we mentioned groundwater is also a conveyance. Number 5, the question of quantity. How much of the pollutant made it to the water? If it's minimum quantity, if the quantity is not that big, then you can clean up the pollutant and or give an ultimatum, like what is to a company to put its house in order, to like what we said in the last lecture about toxic waste discharges. They have to have a toxic waste a treatment plant adjacent to the main plant. Every company that comes to a county or to a state or to a country must have its in its building plan this toxic waste treatment plant adjacent to its major or main company, main manufacturing facility. So the Clean Water Act, to recap, is the main law that governs water pollution and controls water pollution in the United States. We talked about point source and non-point source, what they mean. Dredge materials, we know that dredge materials can include toxic waste, can carry toxic chemicals that are involved in dissolving gold, dissolving other minerals. So this is all for Clean Water Act. It's more extensive. It's more. There are many cases that could be considered. Of course, the law is in reading all these cases to law students in particular. Even though I went through what these cases put as precedents, but reading the case itself and getting the arguments of the lawyers. These lawyers are men of the law. They give arguments, convincing arguments that will make the law applicable, because the strength of the law is in the obedience of the governed. So you have to convince the governed that we need to put this law in place to protect. And once the governed, the people are convinced that this law is just, then they will be obedient to it. If they are not obedient to it, then the law is not worth the paper it is written on. Thank you so much, and let's look at next. I think I will be looking at protection of forest or wildlife protection laws in the United States, and compare that to what we have in Africa or what we ought to have in Africa. Of course, there are laws in Africa, but the biggest challenge is that many politicians, especially in terms of the mining industry, are bribed by these mining companies, or some politicians are also involved in artisanal mining, like what is happening in South Sudan, in the Eastern Equatoria, for example. You have people that are engaged in gold extraction, but they don't know that this gold extraction uses cyanide, uses liquefy or liquid mercury to dissolve gold from ore, and all that will come down to the River Nile. For example, what is happening in Lobonok, there is also artisanal gold mining in Lobonok in Central Equatoria State in South Sudan, and you have a seasonal river. River Kit is a very powerful stream that seasonally flows into the River Nile, and it's connected. It comes from all the highlands around the mountains where this artisanal mining is taking place. And when the rainy season starts, River Kit becomes flooded. You cannot even cross it. Now there is a bridge across it, and it will bring all that rain water will bring all the chemicals used in gold extraction back to the River Nile. And when these quantities become big, then the health effects will be felt by so many people in terms of incidences of cancer and other diseases, liver and kidney failures. And this is happening in Ghana, happening in DRC, and it can happen in South Sudan too. Because looking back, for example, in Ghana, a few years ago, we could not have predicted that Ghana would face this challenge of galamsey or illegal artisanal mining. Water is an important resource that must be protected, and we must protect our waters. South Sudan is blessed, like many other African countries, but South Sudan in particular, because it's a valley, it's a lowland, it's blessed with water resources, enormous water resources that are at risk of pollution if we don't put stringent or strict regulations and laws that protect our waters. In the petroleum industry, in the mining industry, and in all other industries that will come to the country. Thank you. God bless you. God bless Africa.